Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. One issue that's controversial and somewhat difficult to navigate is the issue of the legalities around parents disciplining their children, and in particular, how much force they're allowed to use. Now, the criminal code actually has a provision that specifically addresses that, and it's in the form of an exception to sort of the assault laws, and it says, Section 43, every school teacher, parent, or person standing in the place of a parent is justified in using force by way of correction toward a pupil or child, as the case may be, who is under his care, if the force does not exceed what is reasonable under the circumstances. So, what is reasonable under the circumstances is a bit of a complicated question, but this section in and of itself is controversial, and in fact there have been some calls to repeal it. Most recently, NDP MP Peter Julian has introduced a private member's bill, and I'll just bring that up right here. It is Bill C-273, and it's an act to amend the criminal code, and it just notes it's very simple. Section 43 of the criminal code is repealed. So if this was passed, that section would go away entirely. Now, I don't think that's a good idea, and I'm going to explain why, and I think that Peter Julian would probably also not think it's a good idea. I just think he doesn't quite understand the full ramifications of repealing that section in its entirety. Section 43 does a lot of heavy lifting in terms of allowing parents to parent their children in various ways. Now, I'm not going to get into the sort of ethics of spanking. This section does permit some spanking or physical correction in that sense of, physical corporal punishment. Let's assume, and, this is just for the sake of argument, let's assume that we think that that's bad and that that's what we want to ban. And again, this is for the sake of argument because I know this is going to be controversial, and I'm really not looking to get into a social sciences argument here because I'm a lawyer. So there has been some cases sort of addressing what exactly this section means, because of course, reasonable under the circumstances is a little unclear. So it's important to understand what exactly this allows and doesn't allow. And to do that, there's a case. It's the Canadian Foundation for Children, Youth and the Law and the Attorney General of Canada. So this was basically a case to determine whether that section was unconstitutional because it violated the child's right to equality, their right to security of the person, and whether or not this might constitute cruel and unusual treatment or punishment. Now, this was a six justices out of 9 found that it did not violate any of these rights. However, they noted that the reason why it didn't violate any of these rights is that section, or that little bit that I noted about reasonable under the circumstances. And they spent quite a bit of time defining what they felt that meant. And once the Supreme Court has defined what they feel that means, that's what the law is at that point. That's sort of what we're stuck with. So the first sort of restriction that they put on this is that the use of force for the purposes of correction for corporal punishment only applies to parents. Teachers are not allowed to engage in that. That's one of the things that they limited this. And so if you're wondering what can teachers do, they might be able to use force for other purposes that aren't sort of causing pain. For instance, if they needed to eject a child from the classroom, they might be able to grab them by the arms and walk them out. They also limited this by age. They said that this can't be applied to teenagers because it may cause antisocial or disruptive behavior, and also can't be used to children under the age of 2 or children who are suffering from certain developmental disabilities. And the reason for that is that they said that force is not reasonable if the child's not able to learn from it in some fashion. And so if they're too young, under the age of 2, or if they're suffering from some sort of intellectual disability that prevents them from being able to learn this, then it would not be reasonable to use force. And again, this is the Supreme Court's decision as to limiting things on this. They also limited what kind of conduct that could be done. It can't be degrading, inhuman, or harmful. And it can't actually cause harm or raise a reasonable prospect of harm. So that means that the force has to be of a transitory and trifling nature, is how they describe it, and it can't involve the use of objects or strikes to the head. So the head is kind of a protected space. So all of this is basically a complicated thing. There's more elements to it. It can't be coming from frustration or loss of temper or an abusive sort of demeanor or personality. So the Supreme Court put a lot of sort of effort into defining this. And in the course of that, a lot of people may be surprised by these rules, because there's a lot of people who may say, wait a minute, the Supreme Court retroactively defined my childhood as abusive. Especially, many of my viewers may have been disciplined with, a wooden spoon or a belt. And the Supreme Court has said that that's not protected and that that would therefore be an assault. So that's what the law allows. And if they repealed Section 43, then all of that goes away. And you might be saying, well, listen, I'm against spanking. I'm against all of that. So wouldn't this be a good thing? And again, we're just doing this for the sake of argument because I'm not a social scientist. I'm going to leave that to other people who are better qualified. I'm just going to look at the legal implications. The problem is that there's plenty of times when parents might use force against a child without their consent that we consider to be reasonable and normal and not abusive in any fashion, and in fact expected perhaps of children. So the sort of classic example here is physically moving a child, and especially physically moving a child who doesn't want to be moved. So there may be some current protections that would apply. One of them would be defense of others. So if your child was, for instance, striking somebody else's child and causing them harm, you might have that protection, of defense of others to stop your child from doing that. If your child was striking you, you might have recourse with self-defense. There may also come up, sort of defenses of necessity. And the classic example here would be, let's say, your child, they throw a ball and it's headed right for a busy street and there's cars, but the kid's not thinking. The kid sees ball and is running after the ball. You grab the kid to stop them. That would probably be covered under necessity. So these are sort of protections that would continue to exist if Section 43 was removed. However, there are circumstances that fall outside of this. Let's say, for example, you've got your child and, you've got the sort of happy sort of childhood experience. And, one kid is sitting there playing on a Nintendo Switch. And as they're doing so, they get into a dispute with their sister, and the kid calls his sister the C word. And you disapprove of this for obvious reasons. So you go and you want to take the Nintendo Switch away as punishment, which seems like a reasonable punishment, right? You're going to deprive the kid of this entertaining device for a while. But the kid doesn't want to give it up. And so you use force to remove it from the kid's hands. You're not smacking the kid or anything like that. You're just pulling it out of their hands. Well, that's a use of force. And it seems to me that that's sort of an appropriate corrective use of force. Doesn't harm the kid any, other than, being a little sad that they don't have their toy for a while. But if we don't have the protections of Section 43, it's difficult to see how that wouldn't actually constitute an assault. Another example is, let's say you've got a teacher and they're teaching their class and a kid just starts screaming and won't stop. And they just think it's funny, right? They're not like in pain or anything else. They're just trying to be disruptive. And so the teacher wants to remove this child from the class so that everyone else can learn. Well, that is a use of force that is currently protected by Section 43 and would not be protected if Section 43 was repealed. If your child is having a tantrum at the supermarket, and of course, we should be tolerant of parents who are having a rough day, their kid's having a moment. But the parent might say, you know what, I just want to pick my kid up and take them out to the car so they can tantrum themselves out in the back seat of the car without sort of being a nuisance in public. I wouldn't say that that's an unreasonable thing for a parent to do, but if they don't have the protections of Section 43, now we've got a problem, because that's probably an assault. So All of these are potential, sort of areas where things come up. And it can be really simple. Like the kid doesn't want to put on their shoes. You put the shoes on the kid. Is that going to be an assault? Now, there is sort of an answer that is the common answer to this, and that is police and Crown discretion. So basically it says, yes, those things would be illegal, but nobody's ever going to get prosecuted for it. Like, which police officer would prosecute a parent for, picking their kid up and taking them out of the supermarket when they're in full tantrum? Well, I don't like this philosophy. And, if there is power, it will inevitably get abused. And what this basically ends up meaning is that all parents end up being criminalized, because it's very hard to imagine a parent who doesn't use force in this capacity in some fashion at some time. It's just the kid doesn't want to have a bath, whatever else. This is just sort of part of the, part of the package. And I mean, I don't have kids, but I've sort of been around people parenting their kids. There's these moments. So, this is going to criminalize this huge swath of the population. And then the only reason they're not getting prosecuted is basically that they are relying on the kindness of the state. And that means that the government can take away that largesse at any time. We end up with a situation where we've criminalized all of these people and they can be prosecuted whenever, but we're just going to, we're going to not, because we're just, good people. Well, maybe the government doesn't like you one day and decides to crack down. We shouldn't all be living in fear of the government just deciding to exercise discretion to prosecute us. Further, that discretion ends up getting applied in unequal ways, because if you are a member of an unpopular group, you may benefit less from that discretion than if you are a member of a popular group. So that's a further concern, is that you end up introducing discrimination in the place of discretion. This, I think, is not a great solution, and I don't think that Mr. Julian intends this consequence. I don't think that this is something where he's trying to go out and cause trouble. I think he just hasn't thought this one through. And, there's various groups that have looked at this. Some have come out in favor of repealing this. Some have come out in favor of keeping it. But I am very concerned about what the effects would be if we repealed this. Section 43, as I noted, allows for a lot of parenting activities that are short of spanking and so forth. Even if we disregard all of the controversial areas, Section 43 protects a lot of things that I think would be uncontroversial and expected. So that's kind of my thoughts on this. I don't think that this private members bill is going to go anywhere, notwithstanding the fact that the Liberal Party had previously pledged to repeal Section 43. I don't think they're actually going to do it. I think that's one of those campaign promises that's just not going to be followed through on, because the impact would be real bad. But, notwithstanding the fact that I don't think that this is likely to go anywhere, it's a private members bill by the opposition, I still wanted to kind of talk about it, because I've been getting some questions about, what would this mean? What does this section do? So hopefully that's answered some of those questions. Let me know in the comments below if you think I've sort of covered things, or if there's still questions that maybe you want answered. Please like this video, share it with your friends, subscribe to see more content. And I also want to thank my Patreon supporters at the $50 level, Canada's National Firearms Association, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Jane Babe and Luxor. And at the $20 level, Mark, Kyle Fox, Haywire, Gerald to the Bailey, Dale Nesbitt, Cameron Johnson, Andrew Elsich, and Vicky. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thanks for watching, and I hope this has armed you with knowledge.